Supreme Court Justice Felix Frankfurter once said, "Due process is perhaps the least frozen concept of our law, the least confined to history and the most absorptive of powerful social standards of a progressive society." Due process is not a new concept, but as Frankfurter points out, it changes itself while also shaping the society we live in. The development of procedural and substantive due process indicates which rights we hold most fundamental, and the Due Process Clause of the 14th Amendment certainly does include the interests of the entire public, not just the defendants.
Due process is the idea that laws and legal proceedings are impartial. There are two types of due process, procedural and substantive. Procedural due process refers to the steps that the government must take in enforcing its laws and taking away the rights and privileges of the people. This form of due process dates back to 504 BC, when Publius Valerius Publicola granted the due process rights to all Romans. Procedural due process is important because it prevents the government from invading the privacy and impeding on the rights of the people. For example, the Fourth Amendment's guarantee against unreasonable searches and seizures and the Sixth Amendment's guarantee of a speedy and public trial by an impartial jury all serve as safeguards of our liberties, while also contributing to a standard of fairness embodied within the Constitution.
Substantive due process, the more newly developed of the two forms, refers to the actual substance of a law and whether it extends beyond government reach. We attribute the 1905 case, Lochner v. New York, for substantive due process's prominence, where the court found a substantive right to contract. This form of due process is important because it preserves the rights that are considered the most essential to the functioning of a government. In cases such as Griswold v. Connecticut, Loving v. Virginia, and Lawrence v. Texas, such rights are identified.
Although substantive due process is considered the more recent of the two types of due process, its core dates back to the natural rights philosophy. The natural rights philosophy propounds the idea that people enter into a social contract for protection, and while some rights are sacrificed, governments are established to protect certain other rights. Some of these rights, namely life, liberty, and property, as John Locke postulated, are considered so natural or inherent that they must not be surrendered at any cost.
Where natural rights are not contingent on the government one is in, we find that people's fundamental rights are. We consider fundamental rights as those defined by a government or expressed in a government's constitution. These rights generally extend beyond the basic triad of natural rights. For instance, the right to vote may be fundamental in the United States because it legitimizes our democratic form of government, but it is not inherently natural because not all people belong to a democratic government.
With respect to the functioning of a government, we agree that the Due Process Clause is a constitutional guarantee that includes the interests of the entire public, not just the defendants. In her essay, The Progressive Past, Professor Tracy Almiers alludes to the idea that the due process of minorities can be a miner's canary, alerting the entire public of the issues it faces in society. Furthermore, Almiers finds that a court system that casts an overall image of justice causes the public to be more trustful of it because they view it as legitimate.
We certainly agree with these assertions, but we find that the clause holds even more interest for the public. The Due Process Clause can be used to unearth constitutional rights, not only for the defendants, but for all American citizens and more. Cases such as Miranda v. Arizona and Weeks v. U.S. confirm due process rights for all Americans, with their acknowledgement of the Miranda rights and exclusionary rule, respectively.
The Due Process Clause has also extended portions of the Bill of Rights to the states through the process of incorporation, which began in 1925 with Gitlow v. New York. The system of due process has also allowed minorities to test unfair and potentially unconstitutional legislation. Famous test cases include Brown v. Board of Education and the ongoing California Supreme Court case Perry v. Schwarzenegger.
The United States constitutional guarantee of due process has caused the nation to be at the forefront of justice. The interpretation of due process shapes what rights are held by citizens and people within our jurisdiction. It is imperative to pay attention to the changes in due process which continue into the 21st century. This concludes our statement, and we are now ready for your follow-up questions.